Hello and welcome to Farm Labor 101, an introduction to the new farm labor legislation in New York State. I'm Elizabeth Walters, Deputy Director of Public Policy here at New York Farm Bureau, and I am joined today by Patrick Melfi and Hillary Moreira, who will talk to you through an overview of the laws and that are set to go into effect this January. So this webinar is a first in a series of educational opportunities that New York Farm Bureau is working with Bond, Schoeneck King to provide our members. We will also be having a workshop at our state annual meeting in December that will go through the specifics of collective bargaining, and we'll also be having another webinar later in January. So after decades of holding back this troubling legislation, the politics have set itself up that it was just unsurmountable for New York Farm Bureau and the farm community to fight back this bill. So we worked with our partner organizations under the umbrella of Grow New York Farms to share the impact that this legislation would have on your farms. So due to all the hard work by our members and the honest and impactful testimonies that all you provided over several hearings on the issue, this compromise legislation was formulated. And although at the end of the day, the compromise isn't what we anticipated, it is much improved, I would say, over the original bill, and that is really testament to all the hard work that our farmers put in on this issue. But I will say the fight is not over, and we will be calling on you all again in the upcoming year during the wage board to continue to share how this legislation is impacting agriculture in New York State. And we are going to also work on several tweaks and offsets in the upcoming legislative year. So this is definitely a new area for agriculture in New York State. Labor is definitely a complex system, and we are very fortunate to have two experts with us today. We will be taking questions at the end. I will say, however, there are some issues that we are still working on with the Department of Labor to get guidance for. So we may not be able to answer all questions today, but we will be sure to follow up once we get better guidance from the Department of Labor. So I will now turn it over to Patrick and Hillary, and thank you so much for being with us.
Thanks, Liz. Pat and I are really happy to be presenting in conjunction with the New York Farm Bureau. We all know that this legislation is going to have major impacts on the agriculture industry. So as Liz mentioned, the purpose of this webinar is to provide an overview of what's included in this new legislation so that everybody has an idea of what to expect coming in 2020. At this point, unfortunately, as Liz mentioned, the state has yet to provide any guidance on, the interpretations of some of the things in the legislation. So while we expect that to come at some point, when that'll occur is still a mystery to us. So, I'm sure there will be additional questions at the end here, and we will do our best. But of course, we will keep you apprised as to, the legislation. So. The first slide here, you can see lists kind of by topic, the items that the legislation hit on, and we will discuss each of them in turn. Now, some of these topics we could, spend the entire hour on or so, but this is really meant to kind of give you an understanding of what's coming up, and to the extent you think you need to follow up with additional questions for clarification, or there's something that is particularly specific to your farm, you can always reach out to us. So let's get started with our first topic related to the mandatory day of rest. So effective January 1st, 2020, All farm laborers will be entitled to 24 consecutive hours of day of rest in each and every calendar week. Some of you may be familiar. There is already a requirement like this in the New York State labor law. It's in section 161 of the New York labor law. However, there were some exemptions for dairies and creameries. That exemption for the dairies and creameries has been repealed. There was also another exemption for those employees caring for living animals. They could work no more than 3 hours on Sundays. That also has been repealed. So basically, all farm laborers now have the right for the 24 consecutive hours each and every calendar week. Unfortunately, the legislation didn't just stop there. It also put some other parameters on this 24-hour consecutive day of rest. It provides that whenever possible, the day of rest should coincide with the traditional day reserved by the farm laborer for religious worship. Obviously, this requirement can create some scheduling issues for employers. And what happens when many employees have the same day of worship? And so, hopefully some guidance by the legislature will be important here to help interpret this. And even though it's supposed to try to put it on the day of rest, there is a parameter in the legislation that should, for purposes of weather or crop conditions, and an employee not be able to work for 24 hours, that shall satisfy the day of rest requirement. How that then interplays with the religious worship day remains to be seen. The last part of the mandatory day of rest provision that sets forth in the new legislation relates to the fact that even though they're required to have this mandatory day of rest, farm laborers can actually voluntarily agree to work on that day of rest. However, they must be paid at least 1.5 times their regular rate of pay for all time worked on that day, regardless of the total number of hours they work during the week. And the next topic I'll talk about is the overtime that you may have heard of, about employees now being entitled to overtime if they work 60 or more hours per week. However, for the mandatory day of rest purposes, regardless of whether or not the employee actually works 60 hours or more, you still have to pay them the 1.5 times the regular rate of pay just for the time worked on that day. Think of it kind of as a premium pay in terms of, they're supposed to be off. So the legislature decided to give them, additional monies for the fact that they're now coming in on this day that was slated as a day off of rest. The next topic relates to overtime pay. Now, as I said before, I could spend an hour and a half speaking about just this topic in and of itself. So I do just want to highlight some interesting and very important points that you have to keep in mind when you're thinking about this. So what the legislation actually says is that effective January 1st, 2020, overtime pay for all farm laborers will be required at the rate of 1.5 times the laborer's regular rate of pay for all time worked over 60 hours in a week. Now, as Liz mentioned at the beginning, the original legislation that was proposed actually had this at 40 hours in a week, and I know they worked very hard at trying to get that threshold hours increase. So they landed on 60 hours, which is better than 40. 40 is the baseline for most other employees in New York State. You'll see there on the PowerPoint that the phrase regular rate is both bolded and underlined. And I did that for a reason, because most people think that an employee's regular rate is equivalent to their minimum wage rate. This is not accurate. What the regular rate is, it actually means almost all types of remuneration paid to the employee. So for instance, if an employee receives some type of non-discretionary bonus, I know that some of our dairy farmers provide bonuses to their employees if their milk quality reaches certain standards. Any type of bonus, and that's non-discretionary needs to be added in addition to whatever rate of pay they're receiving. Shift differentials. So do employees receive a premium pay for working a shift that seems less desirable? That needs to be added back in order to calculate the regular rate, in order to properly determine the correct overtime pay. I know some of you may be taking valid allowances for meals and lodging. All of those amounts need to be added back into the employee's rate to determine the appropriate overtime rate. So as you can see, it's not necessarily just what the minimum wage rate that the person is seeing. Somebody's regular rate of pay includes all of these different types of things. What I will say is that this is very complicated. It's complicated for people in all industries, not just this one. It just is new for you guys. Once you get this set up, it's easier to deal with, but the first stages of figuring out what the regular rate of pay is difficult. And it depends and varies by employee. So, you know, if one employee is receiving a non-discretionary bonus, their regular rate is going to be different from somebody else. So this is an area where you're likely going to have a lot of questions, and we understand that. So, you know, feel free to reach out to myself or to Pat to get better understanding on this. But this is a complicated area that we anticipate that you will have additional questions on. So in terms of the overtime pay, other issues that we thought might come up in terms of this specific industry are your H-2A workers. You are still required to pay overtime for all of those workers who work 60 hours in a week, even though they are H-2A workers. One of the requirements there is that you have to comply with all state laws. So that's a requirement. The other thing that we've heard is that many employers have said, well, I'm just going to pay in order to avoid the headache of having to figure out, you know, somebody's regular rate of pay. I'm just going to pay everybody a salary, and then I'm not going to have to worry about the overtime issue. Unfortunately, that is not a good solution, because most farm laborers, they're non-exempt employees, which means that they are entitled to overtime. So you have to pay 1.5 times the regular rate for all hours worked over 60 hours a week, even if you pay them a salary. You can't just avoid paying overtime to pay a salary. You can only do that if you have exempt employees, but in order to have an exempt employee, they have to satisfy 2 tests, the salary basis test and the duty test. But for purposes of today, what you really should take away is that exempt employees are generally those that are higher paid and on a higher level, in the sense of, you know, they have discretion in hiring and firing. They supervise a certain amount of employees. They have independent judgment. These are definitely not your farm laborers that you could just pay a salary and not worry about tracking their overtime. The other thing that we've heard is some people might just be saying, you know what, this is too complicated. I just don't want to do it, so I'm not going to do it, and potentially see what happens. I would caution against that, because the risks of not properly doing this correctly can be very high financially. So obviously, for those of you that may not know, employees have the right to make complaints to the Department of Labor on their own. The Department of Labor, knowing that this law is going into effect, may just decide to perform audits. You know, they can just go in and ask to see your books and your time records and all of those things. Or, you know, the worst of it is if an employee or even a class action of employees gets together and files a civil lawsuit in state or federal court. And, you know, the penalties here are very, very strong, in the sense of you can be assessed 100% penalties, in the sense of, you know, whatever the damages you are, then you have to pay 100% times that as a penalty for failing to comply with the laws. Now, the one other thing that I will say that is very, very important in terms of properly paying overtime is it's an employer's burden to make sure that they maintain accurate time records. The law says that it's up to the employer to do that. So requiring your employees to sign in and sign out, or keeping track of when they work, is extremely important. Otherwise, we won't know, how many hours they're going to be paid for when they hit that 60-hour threshold. And so, some employers these days are using time clock systems because those are generally less likely to be manipulated by employees, but it is your burden to maintain those records. And in cases where employers fail to maintain records, when an employee makes an allegation that they've worked, let's say 80 hours every week, and you say, no, they've only worked, 20 hours in a week, they weren't entitled to any of that overtime. If you don't have the records to back up those claims, they generally side with the employees. So the time records are really, really important in terms of figuring out when somebody actually hits that overtime threshold and is entitled to that overtime pay. So with the overtime pay, the legislation, as Liz mentioned, as I mentioned, the initial legislation included overtime pay to occur after 40 hours in a week. That was increased to the 60 hours. But because of that, the legislation has now created a Farm Laborers Wage Board. So what that is, it's going to be comprised of 3 members, one representative from the Farm Bureau, another representative from the New York State AFL-CIO, and another member who is going to be appointed by the commissioner. They will have the power to hold the public hearings. The first hearing has to be held no later than March 1st, 2020, and they have to hold at least 3 meetings that provide the opportunity for public comment. When those meetings are going to be scheduled or held, we don't know yet. I don't believe anybody's actually even been appointed to the board as of this moment. Of course, the New York Farm Bureau will keep you apprised of those dates because, as Liz said, we are going to need you guys to come forward about the impact of these laws and how they are affecting your businesses. So the intent of the Farm Laborers Wage Board initially is to provide a report and recommendation to the governor by December 31st, 2020. And it's specifically supposed to be considering the extent to which the overtime hours can be lowered below the 60-hour threshold that it's currently set in law. And they want it to provide a series of successively lower overtime work thresholds that are phased in as part of its determination. And the legislation specifically says that it's not supposed to increase that threshold. So go from, the 60 hours to the 80 hours. It's of course only supposed to bring it down. I'm assuming they're trying to get down to the target of the 40 hours, which is what most of, the other employees, that's the threshold to get to. That's the threshold to get to overtime pay and most other industries. So with those 2 topics, I will now turn it over to Pat, who's going to talk to you about organizing and collective bargaining agreements.
Good afternoon, everyone. One of the other big changes in this law is it gave employees the right to organize and negotiate collective bargaining agreements. To understand how important this is, it might be good to have a little historical perspective. The first labor law passed in this country is more than 100 years old. It's the National Labor Relations Act of 1935. The new New York law has some similarities. It has some very big differences too. Now, the right to organize. What this means is employees, farm workers have the right to join a union. It's important. They never had this right before now. This right never used to exist. 100 years ago, forming a union used to be illegal. Now, when the National Labor Relations Act was passed, the right to organize also gave employees the right to vote in a secret ballot election. That is not the case here. It's a very important difference between the federal law and the new New York law. Unions can be certified now based on signed authorization cards, meaning a lot of unions have a little 3x5 index card that says I blank want to join this union and authorize this union to take dues out of my paycheck. If a majority of employees sign that card, the Public Employment Relations Board can certify that union as your union. No election. Very big difference. The second issue is once you get the union, you will have an obligation to bargain with them in good faith until you reach impasse. Now, good faith and impasse, these definitions have also been around for 100 years. What the National Labor Relations Board has defined as good faith is the obligation for the employer to meet and confer with the union at reasonable times. How do you measure that? Well, the National Labor Relations Board will use the number of meetings that you've had, the length of those meetings, and how many days have elapsed between those meetings, and whether or not you've moved in them. Now, will the New York agency use the same definition of good faith? It remains to be seen. I think Hillary and I say it's probably likely that they will. What happens when you do bargain in good faith and you don't get to an agreement? That's impasse. What's the definition of impasse? For 100 years at the National Labor Relations Board, it's been a moving target. One definition of impasse is both parties believe that further negotiations would be futile, or both parties believe that they are at the end of their rope. Another definition, whether a bargaining impasse exists is a matter of judgment. The good faith of the parties in negotiations, the bargaining history, the length of negotiations, the importance of the issue, and this definition goes on to name 10 other things that can be factor into whether there is an impasse. For purposes of the New York law, what one big key difference here is there is no right to strike. So many of you may have been following the General Motors strike and its impact on the economy. That's the National Labor Relations Act. It gave employees the right to strike. The New York law does not give employees the right to strike. And it's worth saying twice because it's that important. They do not have the right to strike. So when you get to impasse, when the employer and the union do not agree, in the private sector, there is a strike. In this law, they have to find a substitute. And the substitute is a mechanism called interest arbitration. You see it in New York in police and fire units. And Hillary does more police and fire work than I do. There is a history of interest arbitration in the state. It is possible that the Public Employee Relations Board will draw on their experience in the police and fire setting to administer this law. But let's talk about what happens when you get to impasse. If it occurs when you cannot get to an agreement, and an impasse can be deemed to exist if the parties fail to get to an agreement within 40 days from the date that the union is certified. And for our purposes, the date of the expiration of a collective bargaining agreement, nobody has those. So at the outset of the act, it will be 40 days from the certification of the union. Either side can request impasse. The employer can say we're at impasse and go to the Public Employee Relations Board, or the union can do it. If the board determines there's an impasse, then the following procedure happens. The board will appoint a mediator. And if the mediator is unable to get the parties to an agreement within 30 days, either party can refer or ask for a neutral arbitrator. Now let's think about the timing here. 40 days after the union is certified, the union might be able to ask for and say we're at impasse. If the Public Employment Relations Board does not decide or police whether there is a true impasse, and if they just pass it through to mediation, you have then 30 days, approximately 2 months. If the mediation is unsuccessful, then it gets moved to the arbitration. And this is where the importance of the act really kicks in. If mediation is unsuccessful, the law provides for a hearing to be held before a neutral arbitrator. The parties will select the arbitrator. They can do it by mutual agreement. It is possible or likely that the parties won't agree on a mediator. In that case, the board will send out a list of approved neutral arbitrators, and the parties will then alternately strike that list. And what does that mean? So a list comes out with 5 names on it. Each side looks at the 5 names, and oh, by the way, we don't know if it's going to be 5 names or 7 names or 3 names, because the law doesn't tell us how many names are going to be on the list. But let's assume for purposes of today, it's 5 names. One side will strike the first person it does not want to be the arbitrator. The other side will strike one of theirs, and it'll go on like that until there's only one arbitrator left. And that's how the arbitrator will be selected. Then what happens? Then that arbitrator schedules and holds a hearing where every issue that was disagreed at during negotiations is put at issue in an arbitration. It could be anything from breaks, wages, where the employee lockers are. Every issue that's contested or a bone of contention between the parties then gets submitted to resolution by the arbitrator. It takes a labor dispute that in the private sector would be resolved by a strike, and it takes it and it's resolved by an arbitrator in lieu of a strike. It is an incredibly important difference. The arbitrator's role, I think, at the early part of this act, as it gets administered, will become bigger and bigger. And the arbitrator's decision in prior cases will become more important for future cases. Now, that arbitrator's decision, now the hearing can take 1 day or 3 days or more, depending on how many issues the parties are arguing about. If it's just wages, maybe that hearing is only 1 day. The hearing gets closed. The arbitrator takes everything that's in dispute and he says, okay, here's how I decided, and here for the next 2 years is your collective bargaining agreement. It is an awful lot of power to give to an arbitrator to determine the terms of a party's collective bargaining agreement. For practical purposes, it means taking part in the hearing, aggressively pursuing your side of the issue are going to be key. Because while the law says there is appeal rights to courts about a final and binding arbitration decision, it's going to be very rare and unlikely that an arbitrator's decision is going to be overturned. The law, or New York state law, only allows for the overturning of an arbitrator's decision in 2 circumstances. First, that there was fraud, corruption, or misconduct of the arbitrator. From personal experience, I can tell you that an arbitrator falling asleep during a hearing is not such misconduct to warrant overturning the award. The second instance where you can overturn an award is where the arbitrator manifestly disregards the law. And what does that mean? Let's talk about what the law tells the arbitrator he or she has to consider when they're getting to their decision. The arbitrator, by law, is required to review comparable employers in the community regarding wages, hours, and conditions of employment. The law does not tell us what the comparable employers are. So in these early arbitration cases, there will be a big disparity between what one side thinks is a comparable employer and what the other side thinks is a comparable employer. Another factor that the law tells these arbitrators they must consider is the interest and welfare of farm laborers and the financial ability of the agricultural employer to pay. One of these is a little subjective, The second, the financial ability of the employer to pay, is obviously objective. Both must be considered. Other factors that the law requires must be considered are a comparison of the following: hazards, physical qualifications, educational qualifications, mental qualifications, and job training. Last, with you taking these 4 to 5 factors and without having a track record of what they mean in the context of arbitration, the first few arbitrations are going to wrestle with how to apply these. You're going to have arbitrators wrestling with what they mean. So until you get a body of arbitral decisions that tell us what they are and what they mean, the hearings are going to be a little bit difficult to manage. That's just the byproduct of a new law. Now, guidance from the DOL may put some more explanation to these things, but right now, we're just left with the terms of the Act. Now, like the National Labor Relations Act, there are unfair labor practices. Employees can't strike, and they can't go through a slowdown. At the same time, employers can't lock out employees or refuse to continue the terms of an expired agreement, which won't happen at the outset of the Act. The last bullet point here is where I think there will be a lot of activity. If you are accused of discouraging employees from organizing or discouraging from them joining a union or signing union cards, that will be and can be challenged at the Public Employee Relations Board as an unfair labor practice. So if employers or a union think that the employer is putting too much or threatening employees that they cannot join the union, they can go to the Public Employee Relations Board, file an unfair labor practice charge. That charge can be administered like any other administrative agency case. At the end of that, the board may say, yes, you violated the law by discouraging union organization, and therefore we're going to allow the union to give us another set of authorization cards, or we don't know whether the board may say you have this union now as a result of your unfair labor practice. That remains to be seen and also subject to guidance. There will be questions on all of these. And these are moving to an interest arbitration scheme in this setting is going to have a lot of bumps in the road at the outset. If you are involved in one of the early arbitration decisions, you're probably going to be reaching out to the Farm Bureau or others to get some help. And it makes sense because it's so new that even the arbitrators are going to have some difficulty applying some of these concepts. The point to take away from today is that if you do get unionized, if you do get moved to mediation and you do get to arbitration, that arbitration is incredibly important because the result of it is going to be with you for 2 years. That is my time. I'm going to turn it back over to Hillary for the rest of the law.
Thanks, Pat. Okay, so I hope we haven't scared you all too much, but we're going to keep right on going. In terms of the next topic we have that was addressed by the legislation was unemployment insurance coverage. So effective January 1st, 2020, employers are now required to maintain unemployment insurance coverage for all farm laborers. The only exception currently is that services rendered by individuals who are basically here as temporary H-2A workers. If at the time those services are rendered, they are excluded from the definition of employment that's defined in Section 3306C of the Federal Unemployment Tax Act, then you may not need to have coverage for those individual employees. However, if you need help figuring out whether or not that definition is applicable to you or not, let us know. It is a very long, there are lots of exclusions, but it is not as simple as just if the employee is a temporary H-2A worker. There are other things that you would have to meet in order to be excluded from that. So all the prior exceptions that used to be in the legislation have been repealed. So previously, this was what was provided in New York state law, that you only had to make employer unemployment contributions if the employer, one of these things was applicable to the employer. So if you paid cash remunerations of $20,000 or more in any calendar quarter, if you employed 10 or more agricultural laborers on each of 20 days during a calendar year or the preceding calendar year, each day being in a different calendar week, or if you were liable for the tax imposed under the Federal Unemployment Tax Act as an employer of agricultural labor. If any of those had previously applied to you, then you were already supposed to be paying the unemployment insurance coverage. If they did not, you now are required to do so, unless, of course, that one exception that I just talked about is applicable. As a rule of thumb, most people, most farm laborers will now likely be required to make the unemployment insurance coverage payments. Now, the next topic relates to workers' comp. So similar to the unemployment coverage, all farm laborers will now be covered by workers' comp. This becomes effective also on January 1st, 2020. The prior exception that only required to provide workers' compensation coverage for all farm laborers who were employed during any part of the 12 consecutive months beginning April 1st of the calendar year, preceded by a calendar year in which the cash remuneration paid to all farm laborers aggregated $1,200 or more. That has been repealed. That is no longer there. So all farm laborers are now covered by the workers' compensation coverage. Now, for those of you that were already paying workers' comp, you should have known that you were required to have a workers' compensation posting up. However, this regulation now requires that that posting be in both English and Spanish. So for those of you who may not have been required to have the posting before because you fell within the exception, or those that did so previously but only had the English version up, now you must post in both English and Spanish. The other new parts of the workers' compensation may require you to actually give a little training to some of your supervisors, farm labor contracts, or foremen, because the law now requires that those people who notice any injury that occurred on the job to inform the owner of the farm about such injury. So, you know, for purposes of you guys, you have to make sure that you tell your supervisors and foremen and the farm labor contracts that they have to provide you with such notice. Similarly, you obviously cannot discriminate against an employee because he or she has attempted to claim workers' compensation benefits, requests a claim form for injuries, or has testified in a workers' compensation proceeding. Now, in addition to the workers' comp, the other legislation change related to the disability and paid family leave was also changed to now include farm laborers. This also becomes effective January 1st, 2020. The prior exception that the farm laborers was not entitled to this type of leave has been eliminated. Paid family leave is generally a rider to an employer's disability coverage. So it's the paid family leave provides partial income replacement for employees who take leave for a qualifying reason, and also protects their job. So, you know, after their leave is completed, they have a right to come back to their job. However, the paid family leave, it's a rider to the disability policy that, but it's generally funded by the employees themselves through a payroll deduction. This is done in order to cover the employer's premium costs. It's a mandatory deduction for those that are enrolled in the paid family leave. So while some employers choose to cover the costs and not pass that cost along to employees, the law was initially drafted and applied today so that those there are certain payroll deductions that you may take, and they are mandatory deductions. I would just caution that there are some, and I believe this is likely going to be applicable to some in farm laborers that many of you may hire, is that there are some temporary and part-time employees who may have the right to waive PFL coverage, as I said before, because it's a mandatory deduction from somebody's paycheck. Unless an employer is covering all the premium costs without passing those along to employees. There are certain employees who, I won't go into specifically who qualifies because that can be a whole presentation unto itself, but there are certain employees who you're required to give them the opportunity to waive the deductions being taken out of their paycheck, but it's very dependent on how many hours they work, how long they've worked for you, and those types of things. So it's a very case-by-case determination. So if you need more information on the paid family leave and who might be entitled to the waiver, please let us know. I would just say that the waiver is at the employee's option. They do not have to, but it is just, you have to provide a waiver to those that it may apply. So in terms of just a little background about paid family leave, people can use the leave. The qualifying leave occurs for somebody to bond with a newly born, adopted, or foster child, to care for a family member with a serious health condition, or to assist when a family member is deployed abroad on active military service. You see what is absent from that list is the ability for somebody to take this type of leave for their own serious medical condition. This does not apply to that. As you can see from the title, paid family leave, it is not to be used for their own serious condition. Obviously, if they get hurt on the job, that's what workers' comp's for. Just as a reminder, employers cannot discriminate against any employees for using the PFL. PFL, obviously paid family leave. And in terms of requirements for employers related to the PFL policies, to the extent you had employees that were not farm laborers, so that were already covered by the paid family leave, you should have already provided some written policy that set forth the rights and obligations of the employer and the employee's rights under the PFL. If you have a handbook, it is supposed to be in the handbook. But because farm laborers had not been entitled to take this leave previously. Obviously, for those who had a policy, you need to give that policy to the farm laborers. And if you never had a policy, you need to have one and then give it to them. So if you need help creating a policy that sets forth all the required rights and obligations, please let us know. The other thing that you must do, similar to what I said about the workers' comp, is that you're required to post a notice regarding the rights related to the paid family leave. Some workers' comp posters may already include the workers' comp requirements and the PFL requirements all in one poster. If that is true, then you should be all set. But just remember, now the workers' comp poster also needs to be in Spanish. So make sure you have the proper postings in place. And then the last topic that was addressed by the new legislation relates to permits for migrant housing. As you can see, every other topic here that I've talked about was effective January 1st, 2020. This one is effective January 1st, 2021. That is not a typo. For some reason, they made this one portion of the legislation effective not until 2021. What it provides is that the old requirement that permits were only required for labor camps that house 5 or more migrant workers was removed. So now permits can be required for labor camps regardless of the number of migrant workers who occupy. Obviously, though, that's not until 2021. We would suggest focusing on some of these other things that are coming up fast and furious as we go. And as Liz mentioned, as we get to the end on some of these overviews, and we will address a few questions that have come in a little bit. As Liz mentioned, in December at the New York Farm Bureau State Annual Meeting, we are going to do a workshop that focuses on union organizing, collective bargaining, and how to ensure that employers do not commit unfair labor practices in the process of doing all of those things. And then in January 2020, please, as the time goes on here and you're starting to look at your policies and practices, if there are specific issues that you're having, please let the Farm Bureau know, because we would like to provide additional guidance on issues that seem to be most problematic for you guys. And also by that time, we're hoping that we receive some of the guidance set out by the state